Okay, the Supreme Court of the United States is gearing up to hear a case that could reshape how millions of Americans vote by mail, specifically whether ballots postmarked by Election Day but received afterwards may still count. Joining us now to unpack what's at stake and everything else going on at the Supreme Court, even if he doesn't know we want everything else, it is David Froomkin. He's an assistant professor of law at the University of Houston Law Center. And if you'd like to join the conversation or have questions, you can call or text us 713-440-8870. David, welcome back to the program.
Hi, great to be back with you.
Okay, I will just start with, I don't understand this at all. If a ballot is mailed in and postmarked before or even on Election Day, you, the voter, have done your part to follow the law. Why? How is it even a question whether or not it is counted after the fact? It's not your fault if the Postal Service doesn't work. There, I'll get off my soapbox now. It's all yours.
So that is certainly what has been the longstanding understanding among lawyers and states as well. That was the premise for Mississippi's law, which is at issue in this case. But according to the Fifth Circuit, Mississippi's law that permits the state to count ballots that are received up to 5 days after the election, as long as they were postmarked by the date of the election, is in conflict with federal law. The Fifth Circuit is the only court to adopt that reading of the federal law. Other courts have not read the federal law that way. And from my perspective, it's kind of hard to understand how they reached that reading. The only thing that the federal law says is that there shall be a date of federal elections, and that date shall be the Tuesday after the first Monday in November. That's the extent of what the federal law says that the Fifth Circuit was interpreting in that case. And I think it's a stretch to understand that text that I just stated as having this pretty radical implication.
I guess my argument would be if you go to a polling location on Election Day and you vote, and for some reason the delivery of those ballots don't make it to the counting center by midnight that day, and it comes in at 12:05, I doubt anyone would say legally they don't have a right to count those votes. They were done on Election Day. And if you see putting your ballot in the post and getting it postmarked is you having done your duty by Election Day, I just don't see a legal argument against this. But there must be, or it wouldn't be going to the Supreme Court.
Well, I think you're absolutely right. And no one is suggesting that it is impermissible for states to continue counting ballots in the days following the election. In fact, it frequently is the case that they will still be counting ballots after midnight on Election Day. We've seen that happen in recent years. Well, if they can continue to count ballots that were cast in person after Election Day, why can't they continue to count ballots that were cast by mail after Election Day?
Right. Well, we have a YouTube comment, and please, if you'll let me know if this is true. Mail-in voting is a necessity. In the entire history of our country, it has never been expected that all votes be counted right on Election Day. That sounds true.
That is true. The law speaks to the casting of votes, not the counting of votes. Those are just different processes.
Who's behind this? Who is going to benefit if these mail-in votes being counted is not allowed? Who's the beneficiary?
So I think that's a really interesting question, and it's an important question to be asking because I think the answer is more complicated than you would think. It's actually not clear that anyone stands to benefit per se. I think that's one of the really interesting aspects of this issue. It's not clear that there is a partisan valence so much as a personal interest on the part of Donald Trump and people connected to him in casting doubt on the absentee ballot voting process. It's certainly not clear that the Republican Party stands to benefit from this change. In fact, the voters who are more likely to vote by mail tend to be older voters and wealthier voters, both of which are demographics that have historically broke in favor of the Republican Party. So it's far from clear that there really is a partisan interest in the conventional sense in this.
And what about if you're in the military, Brian, and you know you're out defending our country and you don't have time to vote until a mail-in ballot and it gets there a little late? Are military votes not going to be counted now?
So the Fifth Circuit really hemmed and hawed on this question. They tried to suggest that it's possible to read an exception for overseas voters and active military members. I think it is a stretch to read the law that way. Uh, Certainly, there is a federal law, the Uniformed and Overseas Citizens Absentee Voting Act, UOCAVA, that says that with respect to votes cast by members of the military and other overseas persons, the deadline for counting those ballots is the deadline chosen by the state. I think the Fifth Circuit wants to understand that provision as creating an exception to what it understands as the more general rule. I would think that it's actually better to read that provision as indicative of Congress's general view that states get to make these decisions about the counting process and associated deadlines. Indeed, Congress generally has deferred to states in this process.
You say deferred, but isn't it legal that it's not just deferring, that the law says states handle elections?
So that's true in two senses. That's the text of UOCAVA and other federal laws. It's also the default rule under the Constitution that says states have the default authority to regulate congressional elections. Congress can preempt those state laws if Congress weighs in. And the view of most courts and lawyers here has been that Congress has not weighed in, that merely specifying the date of the election did not do anything to displace state laws about the counting of ballots.
Let me go back, and maybe we missed this, or maybe I missed it when we're talking about it, because I started with my outrage so quickly on this one. What is the argument for them not counting them after Election Day, not receiving them after? What is the legal stance that they're standing on that says, no, this is not a good thing because why?
So the legal argument that the Fifth Circuit accepted in this case is that what it means to have an election is for ballots to be received by the authority conducting the election. So there's in some sense, a textual dispute between the majority and the dissenters in this case about whether the text election means the receipt of ballots or simply the casting of ballots. We might think that that is a somewhat indeterminate question. And so then we fall back on the background question of, well, if Congress hasn't clearly set a policy, what is the relationship between state laws and federal law? And typically we think if Congress has not spoken to the issue, states do have the authority to regulate federal elections.
Now, David, the justices are also preparing to hear arguments in the campaign finance law cases. Can you talk to us a little bit about that and looking at how much candidates can coordinate spending with political parties?
So this is an interesting set of questions. The general trend in campaign finance law has been to attenuate, or indeed largely get rid of the ability of states to set limits on campaign spending, particularly by so-called outside groups. So the law currently puts more restrictions on the ability of individuals to donate to candidates, the rationale being that that can be a way of facilitating corruption, a sort of quid pro quo relationship between donors and candidates. But if donors instead spend money directly, that's just political speech. And so it's less permissible to limit their ability to spend their own money than it is to limit their ability to give money to candidates. Now, what that means is that there's a lot more money going to these outside groups that are less connected to candidates and parties, and that weakens the ability of candidates and parties to control the messaging in connection with elections, and some scholars worry may promote extremism because the disciplining effect of parties is weakened when these outside groups are able to push messaging in whatever directions very rich individuals want to push them.
And if I'm not mistaken, that's the National Republican Senatorial Committee versus Federal Election Commission, correct? It's that case. Who wants what in that case? Who's asking for which side of it?
So the parties have an interest in being able to coordinate to a larger extent the money that is going to candidates. And so the interesting developments in recent years have really had to do with the incentives created by earlier cases that really opened the door to individuals to spend large sums of money directly on election messaging and limited their ability to give money to candidates. Well, if you also limit donors' ability to give money to parties, then you really are doing a lot to limit candidates' ability to keep up with the vast sums that are being spent by individuals and outside groups. So the idea is that increasing the ability of parties to funnel money to candidates actually, to some extent, can counterbalance the influence of those outside groups that are spending larger and larger amounts on election messaging.
So when we talk about this particular case, we hear so much about campaign finance reform. If this goes the way, if I'm seeing it correctly, is the NRSC, then it's even more money flying into the system as opposed to trying to get a better handle on what's being spent and how to regulate that.
So we're really in a world of the second best here. I mean, the basic problem is that the Supreme Court, in a series of decisions going back to the 1970s, has really opened the floodgates to money in politics. And unless federal courts are willing to revisit that line of cases going all the way back to Buckley versus Vallejo, we're not going to stem the tide of campaign finance spending. Given that, then we have to ask, okay, what's the second best option? And arguably, encouraging money to flow through parties is a better vehicle than allowing it to flow through super PACs and all these independent groups that are simply vehicles for big donors.
How much of this do you see, the campaign financing and the campaign ballots, how much of this do you see as truly just trying to create chaos?
So I think that it's a really important point. I mean, going back to this Watson case concerning the absentee ballot counting deadlines, I do think that this should primarily be understood as an expressively motivated decision, one that's really not motivated by the actual policy stakes of the case so much as what it signals about how we should think about elections. Because there was a significant rise in voting by mail connected to the 2020 election as a result of the COVID pandemic. And I think a lot of the attitudes toward mail-in voting are connected to the broader anxieties around that process and that election. I don't think it is putting it too strongly to say that the plaintiffs in this case are really motivated by the interest in casting aspersions on mail-in voting, suggesting that there's something worrying about mail-in voting. There was an executive order in March that aimed at the same result as the Fifth Circuit reached in this case. And I think there is a broader project by this administration and to some extent the Republican National Committee in this case to cast doubt on the integrity of mail-in voting.
Before we had the rhetoric coming out of, and let's just call it what it is, with Trump and his rhetoric about voting and the distrust in the voting system and all the lawsuits he brought about questioning the results, were we as a nation concerned about our voting system? Would cases like this have come forward had it not been for the, hey, look over here, look over here?
So there have been certainly isolated instances where particular electronic voting machines or particular ballot designs pose problems for the counting process. So you might think about the 2000 election in Florida as a particularly dramatic example. But it simply was not the case that there were systematic problems with our machinery or our election administration. There are ways in which experts agree that we could modernize and streamline the process, but it's not the case that there are systematic problems of integrity in the way that people suggested in connection, in particular, with the 2020 election. It's interesting that they said that about the 2020 election and did not say that about the 2024 election.
Of course,
You might
I wonder why.
wonder
Yeah.
why they.
Let me move you to something else while we're talking about how we get our elected officials. And we have the Louisiana, is it Calais? Is that how you say it? Louisiana, Calais. About redistricting. So talk to me a little bit about what's at play there and how that could actually impact what's happening here in Texas.
So the Calais case concerns the continuing validity of Section 2 of the Voting Rights Act. That's really the main surviving provision of the Voting Rights Act after the Roberts Court has gutted other provisions, in fact, other provisions that did more to protect minority voting rights, in particular, Section 5, which had established a preclearance regime that was a more effective way of protecting minority voting rights. Section 2 provides for the ability of minority voters to sue if they are being deprived the equal opportunity to participate in the political process and elect representatives of their choice. And in some circumstances, it requires states to create majority-minority districts. That is, districts in which the minority population can elect representatives of their choice. The Voting Rights Act only requires that under circumstances where there is racial polarization in voting in the state, such that if there were not the creation of a majority-minority district, the state would be able to systematically deprive the minority group of any influence on the election. So in Louisiana, which is where the Calais case came out of, the Voting Rights Act required the creation of 2 districts in which minority voters could elect candidates of their choice. That's actually a smaller proportion of the population of Louisiana than are Democrats. So, some people say, well, is the Voting Rights Act equal opportunity for Democrats? And I think this is a good illustration of how it is not. It really is a statute that tries to protect minority voters rather than having those political consequences. But the Calais case considers the argument that this kind of race-conscious districting, drawing districts that are expected to have certain demographic consequences, is in tension with the Constitution. And that's a question that the Supreme Court is considering right now.
But here in Texas, though, with the maps that we have drawn, at least the last go-around, not the current one, they've argued both that it was drawn for racial concern and then no, that it wasn't drawn for racial concern, depending on what day you're talking to them in court. So how does the outcome of this case before the Supreme Court impact what's happening here in Texas?
The Texas controversy is really fascinating because the argument that the feds made about the Texas map is that the pre-existing map was an unconstitutional racial gerrymander. That's why the state needed to redraw the map this year. So if the Supreme Court sides with the plaintiffs in Calais and says that it's impermissible for states to draw extra minority protective districts because that would be racial gerrymandering, it really would be underscoring the vitality of the racial gerrymandering doctrine. Now, the problem with what Texas has done in its redistricting this year is that they premised the plan on the incorrect premise that the pre-existing map was a racial gerrymander, which is something that the state has long denied. But under current law from the Supreme Court, if the motive for a redistricting plan was race-based, and it relied on an inaccurate premise that there was a legal need to pursue that race-based redistricting, then the redistricting plan is impermissible. So I think that is a serious legal obstacle for the Texas map that is being litigated as we speak.
That is definitely going to be something to watch. See how all this plays out.
That's right. David Froomkin is an assistant professor of law at the University of Houston Law Center. David, thank you for joining us today on Hello Houston.
Great to be with you.
Thank you.